Voi da cuvântul domnului procuror Dario Scaletta. Vă rog.
Thank you. I must say thank you very much to the organization for having invited me. I've been honored to take part to this meeting. Because of the time and it's not easy to talk after a so brilliant and smart speaker as the one that talked before me. I'm a public prosecutor at District Antimafia Office in Palermo, and I'm specialized in confiscation of illegal assets. In 2000, in the UN Convention against transnational organized crime, the UN Convention underlines that the goal of organized crime group is to obtain directly or indirectly a financial or other material benefits. So after all the speakers stressed this point, there is no need to elaborate more this statement, which is absolutely true for mafia group. When we talk about mafia group, by my experience, we don't think just as organized crime, because mafia as organized crime is something a little bit different. It's not just a crime, it's something that exists, pre-exists at a social level. So it's something that is different. And this is the reason why forfeiting their assets is so crucial. As you can read in my first slide, the judge, Giovanni Falcone, that has been killed in a bomb attack in 1992, said that mafiosi are more fearful of confiscation of their assets than of being arrested, because the organization takes into account to spend 5, 10, even 20 years in prison. When they go out of jail, they get more prestigious. That what they will not bear at all is to be deprived both money and assets. It is widespread argued that in a global society of the area of criminal law has reached a complexity that brings over any national border. As a consequence of it, from one side, it increased cooperation, unification and harmonization process, and from the other side, led to a crisis of the traditional idea of a jus puniendi limited to the national territory. It's not possible anymore today to figure realistically out the jurisdiction problem without taking into account the links among the different judiciary systems and without an efficient, fast collaboration among the judiciary authorities. In the current economic context, where a financial crisis and a slowdown economic growth creates new opportunities for criminals and increased vulnerability in our economy and financial system, the public authorities are facing a new challenges. Protect the illicit economy against criminal infiltration and corruption, and to return criminal profits to public authorities providing services for citizens. Cross-border serious crime, we have realized that affects the functioning of the internal market by distorting competition with legitimate businesses and undermining trust in the financial system. Furthermore, serious and organized crime deprive national governments and the EU budget of tax revenue. So it's necessary to get stronger the ability to fight cross-border serious and organized crime in the EU, and not only in the EU, in a whole world, making easier for member state authorities to confiscate and recover the profits that criminals make from cross-border serious and organized crime. How do we fight against economic and organized crime? In my opinion, are essential two different phases, a prevention phase and a repression phase. It has been considered that repression activity is essential, but it needs to be doubled and integrated by an action that erases the normative and organizational causes for the criminal behavior, unless the risk of repeating it. In Italy, has been created two important authorities in the last years, the National Authority Anti-Corruption and the Financial Investigation Unit. This authority, the National Authority Corruption, has the power to carry out investigation, carry out studies and analysis of the rules of the action made by public administrations, monitor public contracts, expense, and behavior. The Financial Investigation Unit is important for the SOS, that we call Suspect Operation Signal, that are very useful for starting a new investigation. The mission is not only to reduce the risk of corruption, of money laundering, or however unlawful action inside the public administration, but even to avoid the danger that public administration might be conditioned by criminal organization. This criminal organization, like mafia, very often, especially in the areas of the country where they are historically rooted, the south of Italy, but not anymore the south of Italy, even the north of Italy, with the last investigation revealed, but all over Europe, as it's going to be, show their capacity by intensity and spread to move the exercising of public function toward the private value with an effort much more stronger and efficient than in the ordinary corruption. With regard to the repression phase, we must mention the crime provision that we have in the criminal code, like mafia crime, usury, misappropriation of public fund, extortion, bribery, and so on. But are very more effective the security measures like seizure and confiscation of illegal assets and goods. The confiscation, generally speaking, has many characters that are common in different legal systems. As a classic penal sanction, as the objective is the recovery of the illegal profits. As instrument of criminal policy, its fundamental aim is to deter crime by striking their proceeds. As preventive measure, the aim is attacking the economic power of criminal organization and protecting the legal and free market. But the confiscation will still have a symbolic function. A legal action against the illicit asset aims to show that it doesn't worth committing crimes. When we talk about confiscation, we have seen even today that there are many kinds of confiscation. That these are the confiscation, the kind of confiscation that really applied in the Italy judiciary system. We have the classic confiscation that we can say it represents the past. The value confiscation, that is the present, and the extended confiscation represent, especially for Europe, the future, and the three different situations of the conviction-based confiscation, the non-conviction-based confiscation, the third-party confiscation. The classic confiscation is the kind of confiscation that until 1980s was the only one allowed by the criminal Italian code, by the Article 240 It is based on the proof of a direct link between offenses and assets or goods. That is what I want to stress, the direct link. That is one of the most important limits of this kind of confiscation. And the classic confiscation is, it concerns basically the instrumentalities and the proceeds of crime. It has any economy advantage derived for criminal offenses. So it needs a special links and derivation from the offenses. The value confiscation doesn't need any link between the committed crime and the unlawful profit, contrary to the link strictly requested by confiscation provided by the classic confiscation. As a consequence, after a committed crime, the confiscated goods might be completely different compared to the profit or the price of the crime. Because a particular situation of Italian legal system comparing to Europe system and international system is that we don't have the concept of proceeds of crime. We have price, profits of crime that are something a little different. So the value confiscation represented a kind of public compensation for unlawful profits, assume, and from this point of view, a very effective and specific punitive function. Value confiscations needs, beside finding the commission of one of the provided crime and the circumstances, to ascertain that the goods not to belong to third parties, and that the price of the profit of the committed crime has not been found in the assets of the offender. Only at this condition we can confiscate a value correspondent to the value of the offenses. Value confiscation in Italy, in case of several guilty defendants, can even apply for the integral value of the price of the profit of the committed crime in prejudice of any of the participants to the committed crime, even though the price of the profit has been taken or kept by others. The ratio of value confiscation is that goods representing profit or the price of the crime are hardly dispossessed. The value confiscation allowed to confiscate so far the equally value of goods in the disposition of the guilty, without any requested link between the committed crime and the object of confiscation. In front of the traditional one, it is a dispossessed means much more efficient and effective. By the value confiscation, furthermore, it's possible to overcome the frequent difficulties that we face to identify the goods representing the beginning profit, or to overcome the limits with the confiscation of exchange goods, of those goods representing the reinvestment of them. When we talk about extended confiscation, we refer to a modern form of confiscation based on penetrating kind of detection and significant simplification of the evidence. We talk about presumption, inversion of the burden of proof. In this case, people convicted for a serious crime shall have confiscated their asset if the value of this asset is disproportionate to the legitimate income of the concerned persons, and if these latter do not demonstrate the legitimate source of the assets. Then, a criminal conviction is generally a prerequisite to confiscation. An extended form of confiscation is included in the criminal proceeding, and the order of confiscation is issued along with the conviction or after the trial. Confiscation is considered as a penalty related to criminal conduct. It is possible to adopt, even if it is possible to achieve a conviction for death prescription, or other formal reason. Other kind of confiscation that is stressed by the proposal of directive, we have talked this morning, is the third-part confiscation. Investigations make us realize that as criminals often transfer their asset to knowing third parties as soon as they come under investigation. But even before investigation started, many mafia criminals give or transfer their asset to third people, not only relatives, but people that just for getting some money or to make them a favor, just accept to be transferred all these assets in order to avoid confiscation. Third-part confiscation involves the confiscation of these assets that have been transferred by uninvestigated or convicted person to third parties. These provisions requires third-party confiscation to be available for the proceeds of crime of other property or the defendant received for a price lower than market value, and that a reasonably person in the position of third party would suspect to be derived from crime or to be transferred in order to circumvent the application of confiscation measures. In this case, the real problem that we are facing is to find that what Italian jurisprudence of Supreme Court of Cassation called the symptomatic circumstances of outward owner or holder, like personal income, asset owned by the third person, disproportion among the asset owned and the personal income, the kind of professional activity, the kind of contacts that this third person have with the investigated person, use of cryptic language during conversation that we can hear during electronic surveillance. The Italian experience of conviction-based extended third-part confiscation is that one based on the Article 12 sexies of the Law 306 of the 1992. This is a special criminal confiscation measure introduced in the 1994, added this article to the Law of 306/1992. This special form of confiscation is applied to persons convicted for offenses typically related to the activity of criminal groups. In the case of conviction, assets at the disposal of the convicted person and out of proportion to his or income or to his economic activity are confiscated. Before they are seized, during the trial, at the end of the trial, they will be confiscated. And it is worth mentioning that the confiscation order is issued if the defendant has not been able to prove the licit origin of his property. There is an inversion of burden of proof. It was introduced to the Italian criminal system for a very simple reason. The classic confiscation, as I told, requires that prosecutors prove a link between the criminal behavior and the asset which have to be forfeited. This is easy in a case where there is one limited number of people involved in one or limited number of criminal offenses that are well realized in space and time. The burden of proof instead become heavy and even unbearable as a genuine probatio diabolica when the criminal is a part of a structured group, when this group commits crime continuously and professionally during the time and various areas in the country as well as abroad, and when it launders money in illegal as well in legal activity. By this way, they merge the profits. It's not easy to discover, to find out what is licit, what is illicit. It's easy to realize why the classic confiscation seems to be not to be effective enough in most of mafia cases. Then, in the 1992, the Parliament introduced this extended confiscation based on a more simplified mechanism of proof. Indeed, the extended confiscation shared the burden of the proof between the parties. It is to prosecutor to prove that the criminal owns directly or indirectly. Indirectly means by third persons, a patrimony whose value is disproportionate to his legitimate income. And it is to defendant to prove, or at least to allege convincingly, that despite the disproportion, his patrimony has a legitimate origin. During the course of 30 years, the extended confiscation was increasingly applied by the court. But unfortunately, I must say that especially in the court of the south of Italy, where mafia group is really strong, this instrument has been applied more often than in the north. It's very sad to recognize that sometimes it's very bad surprise when you talk to a colleague of mine that maybe live in the north of Italy, that maybe they even doesn't know about these legal tools. Maybe because they have not faced in the past of this kind of criminal behavior. But if you think the way it works, you can realize how effective could be this illegal instrument to fight economic and organized crime from economic point of view. By the end of 2011, Italian justice has confiscated more than 10,000 estate units, including houses, flats, factories, land units, and more than 5,000 companies. It's worth to know that most of these assets were forfeited in mafia cases by courts which made use of the extended confiscation. Being an effective tool for tackling organized crime, the extended confiscation appears to be consistent with the fundamental rights of individuals. So far, this form of confiscation passed successfully the test before the Italian Constitutional Court, European Court of Human Rights. Both courts stated that extended confiscation does not violate neither the right of the property nor the presumption of innocence and the right to fair trial. Seizure and confiscation of criminal assets are normally used in mafia cases. And it is well known that one of the major challenges is fighting mafia groups, especially in the south of Italy, in a place like Palermo. So far, the most dangerous groups are Sicilian Mafia, that we call Cosa Nostra, Neapolitan Camorra, Calabrian Drangheta, or from Puglia, Sacra Corona Unita. But I can say, without entering in too many details, that these groups share three basic features. They exercise a strong control over their origin territories, that is to say, on their civil societies. That's what I mentioned at the beginning of when we talk about mafia. Is not just organized crime, it's something different. It's really and deeply linked to the territory, to the society. And the public authorities with economies, and they manage this kind of links by violence, threat, or corruption. But the core of organized crime is that they don't need to make a concrete threat, a concrete violence, because just the fact that they are part of mafia, it gets a violence, a threat to people who is talking to them. They don't need to make a crime. They just present themselves as being part of mafia. In the meantime, the second characteristic is that they are capable to move and settle into other areas, mainly in the northern regions of the country, but not only, like Europe, USA, Canada, South Africa, Australia, and in the last years, I can give you an example about Germany. They think that mafia was just problem of Italy, the south of Italy. After the butchery that have been made in, I don't remember the name of the city, they realized that maybe mafia is not just a problem of Italy, it's just even their problems. So you must think about this kind of crime, not thinking that it's something that doesn't interest your own country. Unfortunately, the way to spread out is really easily and is really effective. Before the traditional criminal activity, such as trafficking, corruption, and fraud, they carry out businesses activity where dirty money is laundered. In order to have better understanding about how the extended confiscation work, I would like to spend some words about a recent mafia case. It's called Gold Case, dealt by the Prosecution Office of Palermo. In this case, prosecutors succeeded to get an arrest warrant against around 75 persons who were allegedly members of Cosa Nostra groups which were active in Palermo. The arrest warrant were issued by the court upon the request of the prosecution office, an outcome of a complex investigation which Carabinieri carried out for years under the supervision of prosecutors. In the meantime, financial investigations were performed by another law enforcement agency, Guardia di Finanza. This investigation disclosed most of the suspects owned directly and indirectly assets whose value was disproportionate to their legitimate income. How do we obtain information of existence of serious organized crime in Gold Case? By interception of communication with electronic surveillance, testimony of protected mafioso witness. I don't know if you have kind of this law in Romania, but I can say that in Italy it's really fundamental for this kind of investigation, not only for mafia crime or kind of bribery, corruption, but even for confiscation, because most of the time the mafia men just hide people who transferred their assets. So only if somebody tell you, oh, pay attention, that could be a person who owns that asset, you can start an investigation and try to get proof to go to court and ask for a seizure or confiscation order. This enabled the prosecution office, all these kind of tools, to request and obtain, as well by the court, a seizure order in view of extended confiscation at outcome of the trial. In order to contain the risk that many of these assets could disappear, the arrest warrant and the seizure order were executed simultaneously. As I told, the total amount of the assets that were seized was estimated around 300 million euro. I don't know if this was the value. This is the value that has been estimated by the law enforcement agencies, because they are very interested to say, oh, we have seized 300 million euro, but that is not a problem of value. It's a very symbolic tool, because when a mafia man or people see that mafia men are deprived by money, by their assets, by all these goods, they appear weaker in front of the community. And from this point of view, they, at the social level, they will appear weaker and less prestigious than in the past. I must say that for obvious reason, the tracing of the assets have to be carried out in a undisclosed way. For this purpose, Guardia di Finanza had full and quick access to several databases, including land registry, property registry, car registry, tax registry, bank registry. The two law enforcement agencies had to check the financial position of about 400 people including the suspect, the member of their families, and friends of people who have connection. In order to speed up such a massive control, Guardia di Finanza made use of an ad hoc homemade software. It's called Molecola. This software was capable to fish all relevant information from the accessible databases, to process data, and to check whether the condition of the disproportion was met. It helps a lot to get quicker result of the investigation. Generally speaking, this confirms a fact which was lively described by a mafia boss when we said we prefer to stand rich in jail than poor and free. What Gold case demonstrates is that when there is an adequate legal framework, a strong determination and a good coordination between prosecution authority, law enforcement agencies, as well as an easy access to a relevant databases, the asset recovery may be successfully. However, if this is true for domestic action, prosecutors and investigators may face serious problems when they intend to expand financial and economic investigation abroad. Before a request of a massive and a complex financial investigation, foreign authorities are likely not to be available. Reason may be different. Either they have not resources enough, or they don't take such a request as a priority, or they have not the appropriate legal basis, or simply because they deem that such requests would trigger fishing expeditions which do not reserve any follow-up. It is well known that organized crime, and namely mafia group, do not know borders any longer. And this is particularly true also for reinvesting and laundering money derived from criminal offenses. If so, the effective strategy of forfeiting criminal assets at international level needs, in my opinion, three basic conditions. First, a minimum of harmonization of substantive criminal rules about seizure and confiscation. At least different legal systems should be compatible, but not conflicting. Second, an intense and continuous investigative cooperation legal framework is needed to allow the rapid exchange of information. Assets, before being seized and confiscated, have to be sought and found. Third, a mechanism of legal assistance based on mutual trust is essential to the prompt execution of seizure and confiscation orders. Any delay can frustrate the effectiveness of such measures, taking into account the skills of organized crime group to transfer and conceal assets, especially movable and financial assets. In the last decade, EU took some steps towards a system capable to fight organized crime by a more effective and dissuasive tool of seizure and confiscation. These steps were focused on all the above-mentioned conditions. So far, the full implementation of such measure, unfortunately, is neither easy nor quick, and it is foreseeable that a similar process within a larger community of states will still more difficult. I will stop here because it's getting late, but I just want to mention, apart from the instrument of 12 sexies that I've talked, I would like to mention another legal instrument, very, very effective, that we use in Italy. Is a kind of extended confiscation, non-conviction based, and third-part conviction. It's called preventive measures that are very effective because they are a different procedure than criminal procedure, and just two convictions are required to apply this measure. The first One is the asset in question to be at the direct or indirect disposal at the defendant. The second one is the discrepancy between the wealth of the defendant at the low level on his official income or economic activity, or sufficient evidence that the property in question was acquired from criminal activity or resulted from such activity. It's just a same instrument as we say for the one of 12 sexies, but you can apply it even when you don't have a conviction. And that is very effective because when we talk about mafia group and organized crime, it's not easy to get a conviction. Okay, thank you very much.
Thank you very much, Sam.